unmuted and we are live.
Okay, good. Good morning. This is February 20th, 2024, and it's winter time in Vermont today. We had 7-degree temperatures in Bennington this morning when I woke up. And should be 40 by Thursday down there. Just winter in Vermont 2024. So our item number 1 is Proposition 1, and it has to do with elections and qualifications for county offices. Our first witness is a former member of this committee and the former chair of the Government Operations Committee, and a good friend, Senator Jeanette White of Putney, Vermont. Senator?
I would just let know that the senator is having technical issues.
The senator is having technical issues. That's not unusual. So why don't we, Tim, do you have anything to add here today before we hear from Senator White?
I would say that since I last came for the committee, I put some of our thoughts regarding the legal principle of exclusive remedy for the impeachment for the removal of elected county officers from office into writing. You have memos to that effect. It's 1 page. I could reiterate our office's thoughts on that if you'd like, but aside from that, we're also happy to kind of stand by.
I think Senator White is. Do we have that memo, Ben? I think at the last meeting on this issue, Sheriff Anderson indicated that he thought there were certain things we could do without legislation. One was requiring that a certain level of law enforcement certification was necessary to carry out law enforcement duties. And I think that's been established that we can do that, or that the Criminal Justice Training Council can do that. But he then went further to suggest that we could suspend the pay or provide a lower salary to certain sheriffs than others. That was part of his contention. And I remember talking with you, with Senator Hardy, early on, hearing that you felt that that would not be a constitutionally, that would be constitutionally protected. We couldn't, in other words, pay less to the sheriff of Franklin County than we pay to the sheriff of Chittenden. Well, or I guess Chittenden we can always pay more, but Addison County, for example.
I would say that although there are currently statutes on the books that do set pays at different levels for sheriffs, you're right, depending on geographic location, which is presumably correlated positively with caseload and more so Chittenden County being more. And also on the books is a statute that, for lack of a better term, kind of docks the pay of a sheriff should they lose law enforcement officer certification. But I think it's 10%. I have to double check that. However, there remains an open question as to how far you can reduce the salary of sheriff if they lose their law enforcement officer certification before we get to a point which would frustrate the sheriffs from maintaining and holding office. What we consider construction, impeachment, or removal by other means. Constructive, constructive impeachment. Basically, idea that, if impeachment is, again, this sole remedy that is to be used at the exclusion of all other remedies, can you kind of, try to get at that officer by another way of basically saying, okay, we're not gonna pay you at all? You say, nope, that goes against that's kind of removal by different means, impermissible under the Constitution. So, sorry for delivering you perhaps a more nuanced answer there, but, I would say overall, where that line is of where you can reduce it, hasn't been litigated, hasn't been really sussed out. However, I can say something like reducing an elected officer's salary to 10% of what it was certainly would violate the Constitution in our opinion. But how far below that, reducing it to currently 90% of it, how far you can suppress that is an open question.
So it's okay to pay the state's attorney in Essex County and Grand Isle County on a part-time basis. But that's based on the geography of that area. And it's okay to pay probate judges based upon the geography of the population of the county. So in other words, I think my probate judge is 70%, and is still allowed to do their own law practice, just not in probate. But lawyers and judges are under a different status, as I understand it. So they would come under the judiciary. But I'm curious if the only way we passed a law, constitutional amendment, that allowed us to set various qualifications for probate judges. And when we did that, we required them to be attorneys. And as I recall, this was quite a while ago, so as I recall, the requirement that came from the House included a residency requirement in the county. And we rejected that in the Senate, in the bill. It wasn't a constitutional amendment. And we rejected that because we learned that in Essex County, there were only like 4 attorneys and 2 had retired and the other 2 weren't interested. So it would have been impossible to enforce a residency requirement. So at that time, the probate judge in Orleans County was also the probate judge in Essex County. And he was not a lawyer, and so he had to the next election. He was grandfathered and grandmothered in. But we passed those laws. That was the only thing I can remember we ever did with probate judges, that we didn't do to all judges. But we had to have, as I understood it, the constitutional amendment in order to be able to do that. Would you agree?
Yes. The constitutional amendment added, the one you're referring to, added qualifications for office. Their residency, certainly a classic qualification for office, as would age or professional credential, things like that. Without that, probate judges were, and historically were, and would legally be limited to just anybody running for office by other regular qualifications for being a voter and then in term. So really just age and residency of a different kind. And this Prop 1 would do something similar. It would add for the other county elected officials qualifications for office, and then go a step further by permitting alternative means for removing those individuals from office, as well as include that for probate judges here, which they don't have that second part. They just have the qualifications for office, but not the alternative means for removal. So they're strictly limited to impeachment for removal from office. They can be disciplined, they can be suspended, but that's according to additional constitutional provisions that are particular to the judiciary.
I think Senator White is available now. Is that correct?
Yes,
I can see her.
yes.
Morning, Senator. I said some wonderful things about you. You may not have heard me because you were having technical difficulties.
Yeah,
So I'll
yeah,
say them again.
yeah.
It is wonderful to see you. And it is wonderful to welcome a former member of this committee, former chair of the Senate Government Operations Committee. I want to just introduce Senator Hashim. I think you know him. He has taken your seat.
I know, I see that.
Your constitution is left behind here. It's come in handy a few times, so thank you.
So I think you know Senator Bachowski
Hi, Senator White.
Hello.
and obviously Senator Brewer.
Yeah,
So welcome back, Senator.
thank you. So actually, I'm very happy that you let me do it this way because I have a lot more empathy now for all those people that we used to drag up to Montpelier to sit in a committee room and then get 10 minutes and then go away again. So thank you for letting me do it this way. So should I start?
Yeah, please.
Okay. So our Constitution sets what? Am I okay?
Yep.
Okay.
I was just.
Our Constitution sets our guiding principles. We often do not live up to its intentions, and then we need to adjust our behaviors. Our founders made it very hard to change the Constitution and believed it should only be done if there are absolutely no other alternatives. I do not believe this is the case with Prop 1. Prop 1 has actually 4 parts. First is the elimination of the High Bailiff as a constitutional officer. This seems to be a technical correction that was overlooked during previous amendments. While I have no issue with this part, since I am opposed to the rest of the amendment, this alone does not rise to the level of needing to change the Constitution. The other 3 parts deal with the qualifications to run for, to hold, and to remove from office. They are related to each other, and yet each can be looked at separately. Interestingly, they only apply to county offices, not any other constitutional offices. Senator Bruce was right when he said that the House and Senate do have authority and have used it. The example given was Senator McAllister. While it is true that the House and Senate may have that authority, it is not true for any other constitutional office, including statewide and justices of the peace. So if it is a good idea for the General Assembly to have the right to impose regulations on these county offices, why not all constitutional offices? If it were truly needed, there could have been one very simple amendment that stated that the General Assembly had the right by statute to impose qualifications to run for, hold, and be removed from any constitutional office. My guess is that would have provoked some unwelcome negative responses from other constitutional offices. Now, to the 3 parts of my concern. Qualifications to run. It seems that giving the General Assembly the power to impose qualifications to run subverts the rights of the voters to elect and be elected to an office. So far, the only qualifications for any offices are residency. And that complies with Article 8, which says that anybody can run for and be elected to an office having a sufficient, evident, common interest with and attachment to the community. That implies residency. In this proposition, the General Assembly is given very broad authority to impose qualifications. While it may seem evident that any qualifications would be directly related to the position, this is not a given. For example, the other offices aside, what might be qualifications for an assistant judge? So now the second point, qualifications to hold the office. There already exist qualifications to perform certain duties in each office. Sheriffs must be either level 2 or 3 certified and have 30 hours of CEUs each year in order to perform law enforcement duties. State's attorneys must be attorneys to prosecute cases. Assistant judges must take extensive training to perform any judicial duties. All 3 have oversight entities also: the Criminal Justice Council, Professional Conduct Board, and the Judiciary. All of these qualifications to hold the office are already available to the General Assembly. In State's Attorney, the Attorney General in 1979, the court said, "For the powers of the state's attorneys are set forth in the statutes, not the Constitution." So the same might be true for the other offices. Now, methods of removal. It is true that impeachment process is very cumbersome. Knowing that, it seems there could be some. What?
Bahowski has a question.
Oh, okay.
Yeah, I do. So in your sort of view on the qualifications to serve being out of alignment with Article 8, a change like that was already made, I think, in the 90s for probate judges, and that has been upheld.
No, I didn't say that it was out. At one point I did say that I thought it was out of alignment. What I'm saying here is not saying that they're out of alignment. What I said is that the only requirements we have to run for office right now are residency requirements, and they exist in Article 8. They exist in different offices, and Article 8 says that anybody having a sufficient evident common interest with an attachment to the community may run. And I'm saying that, in my mind, that justifies having a residency requirement because it requires an attachment to the community. So, okay.
But my understanding is that in the 90s, and I think Senator Sears gave us a little history on this, is we actually did allow the legislature to set other requirements for probate judges, and we did that in the Constitution. Yes. And I use sort of the royal we.
I agree, we did. Somebody did that in 1994. I probably would have opposed it then also, but
it was done.
It was done, and having done something that is not, in my mind, justification for doing it again. So if I could continue.
Please do.
It is true that impeachment process is very cumbersome, but knowing that, it seems that there could be some attention given to refining and fine-tuning the process. The House hearing is much like a grand jury, which does have established rules of procedure. There is no reason the House cannot establish rules of procedure so that each time this comes up, it doesn't have to be reinvented. That's what I heard the House chairs saying they had to do, is reinvent it every time. It has been stated that there has not been a successful impeachment since sometime in the 1800s. I believe that the 1976 impeachment, and I think that was the right date, was successful. The House found reason to impeach. It went to the Senate, and the person was acquitted. This does not mean it was not successful, any more than a trial where someone is acquitted should be unsuccessful. Being found guilty is not necessarily a mark of success. So the impeachment was success, the removal was not. And there are other potential members of removal, although probably not direct removal. For example, the Pay Act, and I just heard you talking about this, but I'm going to repeat this anyway. For example, the Pay Act sets the salaries for the state portion of these positions. If the person is not capable of performing the function the state is paying for, the state salary could be dramatically reduced or eliminated. This could be done in the Pay Act. It already has precedent as a level 2 sheriff's salary is reduced by 10%. This may not ensure removal, but would certainly provide an incentive to resign. There may be other sanctions that encourage resignation. For example, during testimony on S-17 last year, the Sheriff's Association presented 4 or 5 suggestions that would make it difficult for sheriffs to continue to serve. And this would be true also for state's attorneys and assistant judges. I'm not just saying this is for sheriffs, but you could reduce their salaries also. As stated above, each of the stated above, the powers are in the statutes, not the Constitution. So they can be more restrictive. Each of the governing bodies of the three offices has power to establish qualifications to perform functions. And I quoted the state's attorney versus attorney general. The removal section states that they can be removed for failure to meet or to maintain the required qualifications. The question here is, will the qualifications to run be the same as to hold, or will there be additional qualifications to hold after one is run? If they are the same, one would have to meet all the requirements in order to run. So each office has many requirements to perform different functions. Would they have to meet all of those in order to run? If the requirements are different to hold than to run, how will that be addressed? Or is that a policy simply left to be decided by a future General Assembly? And would there be due process for the person, or could the General Assembly simply remove because the officer failed, the officer, not the police officer, but the office holder, failed to meet the requirements? And if there are multiple requirements, how many would they need to be violated before they were removed? The House and presumably Senate members cannot be expelled for causes that were known to their constituents before they were elected. Is the same applied to the other officers? Probably. The case of Sheriff Grismore is pointed to as one of the main reasons this amendment is needed. Assuming that certification would be required to run, he was certified, so he could run. He has been stripped of his law enforcement duties. That is a sanction. He could have, and with a statutory change, he could have his state salary reduced or removed. And I may be wrong here, but it doesn't seem he couldn't. And that might be an incentive to resign from the office if he had no salary. And I may be wrong here, but it does seem from listening to all the testimony on this that he couldn't be impeached because his constituents knew of his actions and yet elected him. And it does say for the House that you can't do that. So this amendment would not have helped in his situation at all. In conclusion, I will say that I do not believe this issue arises to the level of needing a change to the Constitution. You have heard the Sheriff's Association come out opposed. The assumption has been that everyone else is neutral or supportive. The other entities that testified are neutral because some of their members are in favor and some are opposed. It isn't that they're neutral because they couldn't take a stand. It's because they had split opinions. There is more opposition to this than has been portrayed. And I will just throw out one thing that was brought up before about filling judicial vacancies. And I never quite figured out why this was just glossed over, but the chapter 2, section 53 says that the law establishes procedure for elected offices, and that is the governor appoints those elected people. And section 33 says that the governor can appoint, or that the judiciary can recommend and the governor can appoint except for judicial positions, except for probate or assistant judges. And the reason the governor can't appoint from, the reason that the judiciary, this is from it says it's from a list provided by the Judicial Nominating Board. And that is why the governor can't just appoint and those elected positions, because they don't come through the Judicial Nominating Board. And so they can't be appointed from a list from the Judicial Nominating Board. And that was something that came up before that was, I think, was never dealt with thoroughly. So I do oppose this because I think there had, and I heard the discussion that you were talking about, what would be, where could you reduce a salary to, it's reduced by 10% now, could you reduce it to 10%, reduce it by 90%? I don't know. That would have to be something that would be decided by the courts. But you haven't explored that, and you haven't explored the other possibilities that the Sheriff's Association gave in support of, or in their testimony on S-17, ways that would encourage resignation. And I think that the true same could be said for assistant judges and probate judges.
Thank you. Senator Baruth has a question and or comment, and I have one as well.
So Jeanette, I think one of the things that keeps happening with this bill is people who oppose it say that there are alternate routes. And when we go to our legislative council, they are very frank that they do not believe there's another route. So for instance, reducing the salary, we've been told we would be on very shaky ground in court, and it would undoubtedly be considered constructive removal if we were to do that. And so we've been waived off of that many times. So the same is true of Sheriff Anderson's testimony when he came in and suggested alternate routes. We've run them all down. When we get to the end, Ledge Counsel says that they will not work, and they're very clear about it. So I feel as though if someone opposes the amendment, it's you know, in their interest to keep suggesting that there are other ways to do it. But honestly, from our point of view, that is not what we have been or are currently hearing from our lawyers. So I don't see a way to overturn them because they know a lot more about the law than I do. So that's where I unfortunately come down on potential alternate routes.
So if I might just, I did hear the conversation, even though I didn't think I could hear you. I ended up being able to, with Tim around the reduction of salary. And from what I heard is that you don't know where the point would be that would be considered unconstitutional. And I don't know that it would be unconstitutional to reduce their salary, because there is nothing in the Constitution about salaries. It's a legislative decision already. And if you reduced it by 75%, would that trigger some kind of court? We don't know. And what I heard Tim saying is that we don't know where that line is.
But I think it would be obvious to everyone, including the court, that we were essentially trying to force the person out of office. But I would also mention the McAllister, the whole McAllister affair.
Mm-hmm.
We were told in no uncertain terms that even though we had the power to suspend, we did not have the power to withhold Senator McAllister's salary. So we suspended him until such times as his charges went away, and we did that with the understanding that he would need to be paid in full during that suspension. So this seems to me to comport with what we learned during that investigation.
Yes, I understand it. So if the state, you couldn't suspend anybody's full salary, because the assistant judges and the sheriff both get salaries from other places. So you couldn't suspend that. But if someone is no longer performing the state function for which they're being paid, if they can't perform that function at all, I don't understand why a court would say you can't suspend their salary, because it isn't in the Constitution. There's nothing in the Constitution about salaries. That's completely.
I'm just reaffirming what our lawyers have told us.
I realize that. Yep. Senator Seuss, did you?
Senator, I appreciate your views, and I know you researched this and done your best, but My concern is that any other police officer or law enforcement officer who's accused of doing what the sheriff in Franklin County was accused of would have been suspended. But because he's the sheriff, nobody could suspend him. That really troubles me. Now, I realize that eventually the law enforcement council took away his law enforcement ability. But at the same time, I'm worried. We've had other sheriffs who've done various things, and state attorneys and et cetera, who've done various things. And I'm concerned that there is no way to suspend them and let the deputies handle it. If it was a deputy sheriff or a deputy state's attorney that had done what some state's attorneys have been accused of, they would have been suspended. No question about it. These individuals have 4-year terms, which I think is different from the other constitutional officers and the legislature, quite frankly, where we face the voters every 2 years. And I will say that in Franklin County, yes, the voters knew about it. They tried a write-in campaign. Unfortunately, write-in campaigns are extremely difficult, so he was, for all purposes, was pretty much unopposed. Even though the write-in candidates, there were 2 of them, maybe if there had been 1, it might have been a different outcome. So I think in that case, to suggest the voters knew about it, didn't care or whatever, he was the only name on the ballot, as I understand. Senator Wachowski has a comment or question.
Yeah, no,
Did you want to respond to me?
Well, I was just going to say, did you ever think about perhaps instead of doing it this way, reducing the county term in terms of office to 2 years?
I did, but that's not
that
what.
would also be a constitutional amendment, and there is a bill right now in the Senate, and I don't know what's happening to it, but there is a bill right now to look at county government kind of comprehensively. And it seems to me that is the place then to look at how to deal with these issues, because this shouldn't be just a county issue. There are other constitutional officers that might. So anyway, it does seem that this is just aimed at county.
In the time I've been here, there's often been efforts to make the governors and other constitutional officers 4-year terms, and the Senate 4 years and the House 2 years, but they've never gone anywhere.
Right. Yeah.
I wonder why.
Well, I oppose that too, but Senator Wachowski, did you have a question?
Well, yeah, no, to Senator Sears' point, I think one of there's a couple pieces here. One of the differences, I think, with some of these county officers is they tend to be lower information elections where people don't know as much, whereas the statewide, like, everybody's talking about who's running for governor. So I just think there's a different level of information in the sort of layperson's hands in these county elections. I mean, I certainly have had people reach out to me looking at their ballot going, what even is a probate judge? What does the high bailiff do? So I do think there's a different level of just publicity and information. In terms of shortening the county officials' term, the one place I'd have a concern with that would be the state's attorney for case continuity. I would hate to see state's attorneys changing over every 2 years in the middle of I think there's some level of continuity for how the judicial process works for that 4-year term in that instance. I don't know about the other ones, but that one sort of strikes me as a little problematic.
Yeah, I see that. And I do think you're right that people don't know the officers as well as they should, the county officers. But in our county, I think that people are pretty aware of who they are, maybe not. But that could be said for almost any office that people are running for. That there are uninformed voters out there.
Senator Norris, former sheriff.
Yes. Hi, Jeanette, how are you?
I'm good, thank you. Senator Norris.
In reference to, I'll just spin off from what Senator Bohosky was speaking of. Most offices have several deputy state's attorneys, so I'm sure that they can continue. They're the ones that are assigned to work to the unit for the most part. They can continue it. But I look at Prop 1 as a Band-Aid. Okay, we're looking at 3 or 4 specified positions, constitutionally specified positions. And if you look on the bottom of the page that was supplied to us by our counsel, okay, there's constitutional officers throughout the state of Vermont. There's more 2-year elected constitutional officers in the state of Vermont than there are 4-year elected constitutional officers. What I could get behind and support would be, if we talk about what happened in Franklin County, okay, that individual has been accused of a couple different crimes, but last I know, you're innocent until proven guilty. He has not been proven guilty on any one of those charges. You know, does it rise to the level of conduct of becoming an officer? I guess that's up for discussion. We could have that all day long, I'm sure. But what I could get behind is, since this is a constitutional amendment, and looking at the other one's a constitutional amendment, is I never want to oppress the voters. This is what it's all about. It's about the voters. They put people in office. They should have the authority to take people out of office. So I could support voter recall, which would create a constitutional amendment, along with dropping these terms down to 2 years. It's only the county positions we're referring to. Dropping down to 2 years of a voter recall. I just can't wrap myself around oppressing the voters in the state of Vermont, or even at a county level.
Well, Senator, Senator White, you're the witness. I guess that was directed at you.
So I
How do
would
you
just
feel
say,
about recall, Senator White?
Senator North, Senator Doyle used to always say, we don't need recall because we have it every 2 years, and it takes longer than that to do a recall. So you're right, if we had 2-year terms for county officers, we wouldn't need a recall there either.
I'm talking about all constitutionally elected officers.
Right.
Let's not put a Band-Aid on 3 or 4 positions. If we're going to make an amendment, which I consider a serious thing to do, to go into our constitution, change something, then let's do it, because 2 years down the road, if we're still here, we could be looking at one of these other offices too, I might add.
Senator Hashim, and then Senator Powell.
Thank you. Actually, a question for Tim, if you happen to know the answer. If we wanted to allow for voter recall, as was suggested, would we have to make this amendment to our constitution first?
In order to facilitate a recall for any office in the state that's not a local office, which recalls are permitted by charter in some instances, yes, the Constitution would have to be amended to permit that.
Thank you.
I want to just say I oppose recall. I sat on the Bennington Select Board for 7 years, and this issue came up a few times. And first of all, ours were 3-year terms in Bennington. Secondly, the process to go through to recall someone could be because of malfeasance, but also could be because they didn't like what you did. So you wanted to set the bar as high as you could for the number of people to sign a petition. And I found now that, it's not hard to get people to sign petitions, especially in this environment. And third reason for me opposing recall is what I've seen happen in San Francisco and other areas, particularly with state's attorneys, who may be a little more progressive than some in law enforcement would like. And we saw that in California with the governor, who was recalled and but was successful in defeating them or winning. He got recalled, but I think he was successful in winning, or I don't remember.
He didn't get recalled.
He didn't get recalled.
Yeah.
But Governor Schwarzenegger, and I can't remember who was
Gray Davis.
And Newsom, you're
Yeah. Huh?
the Governor Newsom, you're
No, Gray Davis got recalled and
Gray Davis
Schwarzenegger
got recalled,
Yeah.
and Schwarzenegger became the governor. So I'm not sure if we're looking at malfeasance in office and a recall, that would be one thing, but if we're looking at just political decisions, I'd be worried.
So let's look at malfeasance then.
So if you had 2-year terms, you wouldn't.
One's
need-
malfeasance. We may define malfeasance differently.
Senator Hashim actually asked the exact question that I had, which was whether or not we would actually have to make this constitutional change in order to allow voter recall.
Right. And I would just say, were we to go down that road, we would have all of the same arguments we're having about this bill, many of the same ones, which are based on the idea that a legislature is going to have to act in the future and what crazy things might they do. So ultimately, I think that recall idea gets us out of this immediate decision, but it puts us into lots of different problematic areas. If we go down
I
that.
think
Could
Are
I-
you inferring we're doing crazy things?
What's that?
Are you inferring we're
Senator
doing crazy things? Just
Can
yeah,
I
asking.
Senator White.
Can I comment on the recall issue, just one?
Sure.
time?
I think you're opposed.
Yes, I am, because I don't think recall is the answer. It's very complicated, as you say, and I saw it when we were dealing with town charters. Towns would come in with the most ludicrous forms of how they were gonna do recall. It was like a spider web, kind of. You couldn't even understand it. So I don't support recall, but the thought that I had in my head just went out. But if you had 2-year terms, you would not need recall, but if you wanted recall, you would have to have a constitutional amendment, but not this one. You could just have a constitutional amendment that said the answer to the removing those people from office is the recall, and the legislature would have nothing to do with that recall. That would be up to the county voters. The legislature wouldn't be involved in that recall at all, because it's not a statewide office. So if you allowed for recalls, it would be the county that would perform the recall, not the legislature.
Senator Wachowski, final question.
Yeah, and my question is actually, I think, for Tim, and just because we're getting it on the record, I also am not supportive of recall. But if this constitutional amendment passes, the mechanism a future legislature chooses for removal could be recall, correct? Because the Constitution doesn't say the legislature will remove them from office. It says they can determine a process for that.
Let's see, and procedures for removal from office for failure to meet or to maintain required qualifications. It is broadly written to, I would say, likely permit recall, although procedures for removal from office, I mean, let's see, for failure to meet or maintain requirements. It is certainly generalized. I think it could be argued that that would permit recall. I'd like to take the opportunity to think about that a little bit more and provide you certain, just because that's a
Yeah.
I'd like to research that.
I just want to correct one thing, and not correct, excuse me. I want to use a different term. When you were talking about impeachment, you said the sheriff was acquitted. And I always had trouble with Donald Trump saying he was acquitted. He just wasn't impeached.
Well, he was impeached. He wasn't
He was
convicted.
I mean, he
impeached,
wasn't convicted,
but the
Yeah,
Senate
but he
did
was
not
impeached,
take
yeah.
it up.
but he wasn't acquitted. I never felt like the Senate, US Senate acquitted him.
No, but in the 1976 case, the Senate did actually acquit him. The person was impeached by the House. It, like a grand jury, they found there was enough evidence, and then it went to the Senate. And what I understand from Senator Baruth, I think it was watching the caucus, I'm not sure where you said it, but that the Senate has figured out better procedures for taking that on, so that if Griswold was impeached and it went to the Senate. The Senate had actually come up with some procedures so that it would be smoother. But in 1976, he was impeached, but he was then acquitted. So you can't say that it was unsuccessful because it was successfully impeached.
Well, just to clarify, what I said was that we had researched the 76 impeachment with the Senate Secretary, and we had spent a large number of hours doing that, and that it would, as it did in 76, it would consume a large amount of our legislative agenda for that particular year. So it wasn't that we found a more efficient or smoother way to do it. We rediscovered how difficult it is to impeach somebody.
I imagine costly too.
Oh, yeah. No, and you know, you look at what the House has already spent on their impeachment.
I thank you, Senator White.
Can I just ask, I don't understand why impeachment process can't be refined. The grand juries have rules of procedure, so you shouldn't have to reinvent the rules of procedure every single time there's a proposed impeachment.
Well, but Jeanette, even if we refine the procedure, what I was told is that it would take several weeks to conduct the trial itself with due process and representation on both sides, the full scale of motions, et cetera. So the Senate, which only has, as you know, better than anybody, 6 months or less to do its work, we would spend at least a couple of weeks of that time sitting as a jury listening to an impeachment. Just seems to be an unconscionable amount of time to thrust onto the Senate when there are, I admittedly, a constitutional process is long and winding, but if the voters finally approve this amendment, we would have the ability to create a statute that would not require that massive impeachment process, but would be more sensible, in my opinion, about when somebody can and can't serve. So right now we have a sheriff who can't, to perform any law enforcement duties. That to me is a crazy state of affairs. So in any event, thank you, Jeanette. I appreciate your testimony.
Thank you for letting me.
Thank you. It's always good to hear from you and see you, and hopefully we'll get together sometime over the mountain when the mountain clears.
Yeah, I miss you all.
I miss you. All right, Jeanette, thank you. Our next witness is Tim, but I don't know any more than the memo, but if you want to take the witness chair, please. Tim Evelyn, legislative counsel.
Thank you for having me. And yep, again, for the record, my name is Tim Devon, Legislative Counsel. I'm happy to answer any lingering questions that committee members may have. Before you, you have a memo. It's very brief. It's just one page, and really just kind of puts into writing some of the comments I made on behalf of our office last time I was before this committee. In essence, just reiterating that impeachment is the exclusive remedy for removing constitutional officers from office, and just kind of providing a little bit of supportive, persuasive case law to the issue, just because this has not been directly addressed yet by the Vermont courts, likely given the infrequency of such impeachment occurs.
So if the constitutional amendment is really three things. One, the legislature could set qualifications to run. The legislature could set qualifications to hold office. And the legislature could set removal from office. If removal were to be able to suspend, someone rather than removal. I've heard the argument that it would be the voters. So if we changed it to suspend rather than remove, how would that impact the constitutional amendment?
Sorry, let me see if I understand your question correctly, is that if we change the language in Prop 1 to from removal to suspend,
give it to the judiciary or something like that.
Sure. If that language were to be incorporated into the Constitution, it would by just de facto become constitutional then, and of course, an officer would be able to be suspended.
If the judiciary had the right to suspend, for example, they can suspend a probate judge, they can suspend an assistant judge, as I understand.
The judiciary has additional allowance under the current constitutional language to suspend judicial officers that does not really have a parallel or occur yet in our current constitutional construction. Prop 1 would change that. But yes, right now probate judges can be suspended, but they can't be removed from office by the judiciary. But that is only facilitated by additional language in the Constitution, which is not found for elected county officers.
Can the judiciary suspend assistant judges?
Assistant judges? I believe they can. He nods over here, but I believe they actually have suspended recently. This was maybe about this time last year. It was either probate or assistant judge. I have to double check.
I think
let me pull up the
judge.
Exact language in the Constitution quickly. Bear with me here so I can actually cite why they can do it. Okay, sorry. So it's section 36 of the Constitution. This is suspension and removal, and the justices of the Supreme Court and judges of all Supreme Court, in the exercise of its disciplinary power over the judiciary of the state, may suspend justices of the Supreme Court and judges of all subordinate courts from the judicial function for such cause and in such manner as may be provided by law. So that does apply to other judges, whether elected or not.
But it's only the judicial function of the assistant judge, not the county administration.
Correct. Yes. That's an excellent nuance to bring up. There are certain judges, really just the assistant judges, which have extrajudicial responsibilities and duties, of which would presumably still be being enacted by those individuals, even if they were suspended by the judiciary of their judicial functions. And to remove them from office and prevent those assistant judges from performing those administrative duties would, again, return to impeachment. It's the current exclusive remedy for doing that in the Constitution.
Right. Thank you. So that is an option.
To clarify, do you mean if we pass Prop 1, the statute that we pass could make suspension the alternate? Yeah. You're not suggesting changing Prop 1?
No, I'm not. Except, I'd like to know. It's clear to me that nobody knows, even high bailiffs don't know their job. And we're taking them out of the Constitution reference. Is there an effort somewhere to define the responsibilities of the high bailiff so that they, I mean, when the sheriff was in Addison County was out of office for 4 hours while he was being detained. The high bailiff went on Facebook and said he was now the sheriff. I'm not sure. It sounded to me like back when
Alexander Haig
said he was next in line, and I'm not sure he was the sheriff, frankly, for those 4 hours. But once we take them out of the Constitution, is there any? What do we do with them?
Once the quality of being a constitutional officer is removed by Prop 1, presuming it would be ratified, the high bailiff would still exist in statute as it currently does. There's 15 statutory references to the office, some including its duties, which really are, about serving legal process for the most
I
part,
would hope that.
and redundant with other, state offices.
Should Prop 1 pass, I would hope that the legislature would take a look at high bailiffs and define at least what their duties are. But it was kind of odd when I read that he was sheriff for 4 hours, and I don't know what he did. He's not a law enforcement officer, so I assume he did no law enforcement. Maybe he helped convoy. I don't know. It drives me as an odd position to have. And we elect them every 4 years, and most people have no idea what they do. We had a race in Bennington for high bailiff.
Really?
Yeah, and
TV commercials?
County. Pardon?
TV commercials?
No, there were no TV commercials, but it was clear that some people thought it was more to this day. I remember one time a guy running for probate judge said he's gonna take care of all this, I mean, not probate, assistant judge, he wanted to focus on sex offenders, and I didn't have the heart to tell them that they don't have any criminal. Okay, Senator.
Thank you. So quick question about Article 8, and I think if I understood correctly, we had previously heard about the residency requirement that it establishes for folks who want to run for office. And at the end of it, it also says, be elected into the office agreeably to the regulations made in this Constitution. And so, assuming, hypothetically, if this were to pass as it's written, and the ability to make by law qualifications for the election to and holding of such office, those would then also be considered regulations made in this Constitution, or does that question make sense?
I think I understand what you're saying. Article 8 would be in harmony with another constitutional, with this constitutional amendment for it to be adopted and ratified. There's the idea that this language at the end of Article 8, let's say, agreeable to the regulations made in this Constitution, is a reference to other parts of the Constitution as adopted. This would be the regulation here, and that term is vague. It's not really used here, and it's not a regulation in the typical way we think of rules and regs or something like that. Really, it's just this should be read to say another facet of the Constitution, and so that facet here would be that permission for that enabling authority for the state legislature to, by statute, determine what those qualifications for and removal, means of removal from office are.
Thank you.
So rather than continue to focus, you had a question, Tom? Are there any other questions for Tim? Tim, thank you so much for your help too.
Thank you.
In all of this, and your memo, which is extremely helpful.
Yeah, very.
Would entertain a motion.
I move that we find Proposition 1 favorable.
Senator Bowski has moved that we report favorably Proposition 1 as amended in draft 2.1 that was approved by the Government Operations Committee. Is there any further discussion? Okay. Would you please call the roll? Ben. Your name is Ben.
Yes.
Senator Norris,
No.
Senator Gromowski,
Yes.
Senator Shu,
Yes.
and Senator Sears.
Yes. And I'd appreciate the opportunity to report this, assuming I have a voice by the time it comes up.
It comes back. Mine, you remember mine?
Yes, I know. That's what I was referring to. I don't want to be.
You don't want to be reporting as bad.
I don't want to report.
It was about a 24-hour drop off of my.
Yeah, I felt this morning like I started to talk with you for a few days ago.
Like Batman.
Oh, well, this is gonna be a fun day, and I have my Mrs. Murphy speech on it. You don't remember Mrs. Murphy?
I do want to just let you
It
know.
has to do with property tax.
Oh, okay.
The one power and duty of the high bailiff says they may serve writs which the sheriff is incompetent to serve. So perhaps that could be interpreted as, I get to be the sheriff if the sheriff's in jail.
Then we get into what's competence.
But they can arrest the sheriff. Too, right?
Yes.
But they aren't the sheriff.
Well, again, I think open to interpretation. If they may serve writs which the sheriff is incompetent to serve, are they then the sheriff if the sheriff is incompetent?
I guess in terms of serving writs. I don't want to be pulled over by the high bailiff. All right, thank you very much. Eric, would you join us, please? Just proposition day. Do we have Prop 4?
Yes.
We have two witnesses scheduled. One is scheduled for Mark Hughes. In Proposition 4, I think there are two issues that have been raised in terms of any amendments to Prop 4. The first was raised by Peter Teachout, and I think it's an important one, and that is that moving this from being a part of the Common Benefits Clause to its own particular constitutional amendment would perhaps be a better way to do it than leaving the Common Benefits Clause as is.
Yeah.
So, since that's issue number one, and issue number two that I've heard is religion being a part of this proposal that people have read. So I would like to call on first Bernine McGinnis, policy analyst for the Vermont Family Alliance. Agree? You can join us.
Is Eric going to say anything to us, or?
I don't know, were you gonna say anything?
No, you asked me to join Thunder Series, so I did.
That was, all I've had is Dayquil.
Not feeling well really messes with your ability to function. I get it.
That was dumb, I'm sorry.
No worries at all. I'm right here in the room.
Well, you got your computer back, just remember that.
Thank you.
You know what, my name's Renee McGinnis from Vermont Family Alliance. I'm a policy analyst.
Thank you.
Yeah, I'm very happy to be with you in person today.
I pass it.
Yeah. Yes, so Vermont Family Alliance is a parental rights and minor protections advocacy group. And I'll just start right off the bat that Proposition 4 is on its face unconstitutional. It violates both the Vermont state and US constitutions. It creates a hierarchy of rights that oppresses the rights of specific religious groups. It creates an unconstitutional mandate through which oppressive laws could be passed that would marginalize religious rights, along with providing the framework for frivolous lawsuits. Under Proposition 4, state-sanctioned marginalized groups would be the recipients of benefits and programs not afforded to all persons under the proposed amended language of Article 7 under Proposition 4, the purpose section 1B. Proposition 4 intends to deny Vermont citizens their right to appeal their case involving equal rights discrimination to the Supreme Court of the United States, which violates the Supremacy Clause, Article 6, Paragraph 2 of the US Constitution. The purpose section, the January 30th meeting, that question came up about whether or not the purpose section appears on the ballot. It does not. The purpose section was not covered during the walkthrough, and I think that it's very important that it is covered. It expresses the intent of Proposition 4, and people, in order to be able to vote on this, would need to know the intent behind the proposed amendment. So yeah, the purpose section is unconstitutional, and it violates the spirit and intent of the law under both Articles 1 and 7, the common benefits, Chapter 1 of the Vermont State Constitution. Page 2, Proposition 4, Section 1, purpose. Yes, it does not appear on the ballot before the voters. And so I found a publication by Professor Teachout. It's called Trustees and Servants, Government Accountability in Early Vermont. And it lays out the accountability of our legislators. And you know Article 6, so I don't need to read through that entire article. I gave you the link to Professor Teachout's article from 2012. And if you just skip down to the middle of the page where I have written page 46 out of 49, it seems, I'm quoting from what Professor Teachout wrote, it seems fairly clear that the framers of the state's first constitution were genuinely committed to the principles of democratic accountability. They did so by requiring that the doors of the assembly be kept open, by setting up a procedure for printing a roll call vote on particular measures, and by establishing a cooling off period for legislation during which acts under consideration would be disseminated to the people. So my concerns are, how do you intend to educate the public on the purpose section of Proposition 4 and the intent to roll out benefits and programs for state-sanctioned marginalized groups at taxpayer expense? There's expenses attached to this proposal, and any legislation that would be developed and passed under Proposition 4 that has money attached to it. The committee did not review the purpose section of Proposition 4 during the walkthrough. Legislative Council did not provide a walkthrough of the relevant purpose section, and there was no testimony received on the purpose section. There's problematic language in the purpose section 1A, and I'm quoting, "This amendment would expand upon the principles of equality and liberty by ensuring that the government does not create or perpetuate the legal, social, or economic inferiority of any class of people." So Proposition 4 intends to do exactly the opposite by elevating the status of state-sanctioned marginalized groups over other groups. This proposed constitutional amendment is not intended to limit the scope of rights and protections afforded by any other provision in the Vermont Constitution. That's written in the purpose section. And so this statement does not appear in the language of the amendment itself. Judges would not be rendering decisions based upon this alleged intent. Section B, I'm reading it here, providing for the equality of rights as a fundamental principle in the Constitution would serve as a foundation for protecting the rights and dignity of historically marginalized populations and addressing existing inequalities. This amendment would reassert the broad principles of personal liberty and equality reflected in the Constitution of the state of Vermont with authoritative force, longevity, and symbolic importance. To the contrary of Section B, the intent of Proposition 4 violates the spirit of the law, the broad principles of personal liberty and equality under Article 1, Chapter 1. So Article 1 is there before you. I don't need to read through it. You all know it. And so unalienable, as you know, is defined as impossible to take away or give up. So it's not the state's place to take up or give away the right to pursue liberty. Citizens' rights to enjoy, acquire, pursue, possess, and obtain are all active verbs, with the expectation that individuals actively pursue prosperity through effort and work, not through state-sanctioned programs and benefits. Proposition 4 intends to create exclusive and separate emoluments and privileges from the community, which is in direct opposition of the intent of the Common Benefits Clause under Article 7, Chapter 1, as understood in Baker versus the state of Vermont. That case was brought up several times as a case where equality of rights was decided in court under the Common Benefits Clause. So Baker versus the state of Vermont, that decision in Section 2, see the historical context. This is the same, or on top of page 4, this is the same quote that Professor Teachout cited, except in the full context by including the final sentence in the paragraph. So I can read the whole, it was in Peter Teachout's testimony, it's in his written testimony. The historical origins of the Vermont Constitution thus reveal that the framers, although enlightened for their day, were not principally concerned with civil rights for African Americans and other minorities, but with equal access to public benefits and protections for the community as a whole. This concept of equality at the core of Common Benefits Clause was not the eradication of racial or class distinctions, but rather the elimination of artificial governmental preferences and advantages. And so the sentence following after that, that Professor Teachout left out, is that the Vermont Constitution would ensure that the law uniformly afforded every Vermonter its benefit, protection, and security, so that social and political preeminence would reflect differences of capacity, disposition, virtue, rather than governmental favor and privilege. I do believe that every single person sitting around this table earned their position through hard work and merit and through the votes of the people, and were not given their seat sitting at this table, just as I was not given my seat on Vermont Family Alliance. It took a lot of work and effort. So I gave you the source from which you can find that information. Proposition 4 intends to create a privileged cliques based on race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, and national origin. National origin.
Mr. Chair?
Yeah.
If I might just, so I'm following your argument, but I'm having trouble plugging it into what we're actually being asked to vote on in terms of the proposition. So my reading of this is that it says the government shall not deny equal treatment and respect based on these categories. You seem to be reading it as giving them extra something. You use the word emoluments, which is a perk or a salary or a benefit. And you call them a privileged clique. The language just says that they shall be accorded equal respect.
Yeah, I think when you start, let me see. It's section B.
Yeah.
I believe I read it all. When you are getting into addressing inequalities, all the testimony received indicates that there would be.
No, are you looking at section B of the purpose?
I am.
But again, it says providing for equality of rights. How is that privilege or emolument? How is equality of an unearned privilege or an emolument? The emoluments clause is designed to prevent people from, using their office for illicit gain.
Mm-hmm.
How is it illicit gain to be equal?
I'm not sure I understand your question.
Well, I don't.
There's an intent under purpose B.
Yeah.
That I don't think we can get around giving the testimony that's been provided.
It's just twice in two sentences asserting equality of rights. But
why does this need to be reasserted?
Well,
It's already,
but
it's
can
already, yeah.
Can I just ask you the question?
Sure.
How is equality of rights making these named categories and making sure that they achieve equality?
Yeah.
How is that a privileged clique or an emolument?
I think that if you allow me to continue with my testimony first,
Okay,
that you might get the answer through that, and then if you don't,
But you can't answer me now.
I think if I continue, I think you will
I
get
don't
the
think I
answer.
will, but anyway,
Well, allow me to continue,
Sure,
because
go
I
ahead.
think the answer will be in there.
Okay.
Okay, thank you. Proposition 4 violates the following articles under Chapter 1 of the Constitution of the State of Vermont. It violates Article 1, all persons are born free, natural rights and slavery prohibited. Article 3, freedom of religion, right and duty of religious worship. Article 13, freedom of speech and the press. And Article 18, regard to fundamental principles and virtues necessary to preserve liberty. So I think I already covered the spirit of the law, Senator Baruth, and
That's not my question. My question is about your choice of words describing what this particular amendment.
It does, when you're planning on rolling out programs and services that
Nothing here talks about rolling out programs and services.
but that's the intent behind it.
I disagree. I disagree.
Okay.
What we're dealing with is a clause, and I will read it again, that the government shall not deny equal treatment and respect under the law on account of a person's race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, or national origin. That doesn't promise a program. It doesn't constitute an emolument. It doesn't make those categories part of a privileged clique. It says that they shall be equal to others.
But that intent does appear in the purpose section, sir.
And that is where?
Section B, page 2.
But where do you see promising to roll out programs?
It says it would serve as a foundation for, it doesn't say it explicitly, for protecting the rights and dignity. It doesn't say it explicitly.
Doesn't say it implicitly either.
So what's the, okay.
In other words,
Historically marginalized persons.
Yes, protecting people's rights who have had those rights denied. That doesn't, someone might, in an uncharitable way, say that this is the nose under the tent, and inevitably in the future it will lead to government spending. But I think those people would make that argument no matter what we do. But the language here is very clear that it is promising equality, and that's it.
Just a quick question. I understand where Senator Booth is coming from. I guess my question to you would be, if the word religion was included in here, would that eliminate everything that your concerns would be about? Are you saying other groups are getting special treatment because they may
That seems to be where this is going, given Senator Lyon's statements in the introduction. I would disagree. I would say no, outright no, that probably would not change it for me. I don't agree with inserting the language within Article 7. But the testimony that's been received from Jay Green, from Professor Teachout, if I may.
No.
If we want to address problems of unfair and unjust discrimination in an effective and meaningful way, we need a provision in the state constitution that will provide our citizens and courts with the right tools to do so. I think one of the intents of this bill, according to Senator Hashim and legislative counsel Eric Fitzpatrick, is that this amendment is intended so that people cannot seek recourse on discrimination cases past the Supreme Court. They would not have access to the Supreme Court of the United States. That any case on
Where did I ever
discrimination.
say that
It's-
people
it's
would not
in-
have access to the US Supreme Court?
There were statements were made. I'm sure I have the transcript with me. I don't know if we need to go all the way back that far.
I'd like to know. I'd like to know, please.
There was discussion between legislative counsel and Senator Hashim on January 30th. Okay, so Senator Hashim, so this was January 30th during a walkthrough at 13 minutes in. Senator Nader Hashim, I think maybe expanding on it, Eric, if you could. And let me see if I need to go back further. Yeah. Senator Hashim, you said, I think maybe expanding on it, Eric, if you could touch on the topic related to litigation, if something is going to the Vermont Supreme Court versus the US Supreme Court, how do those pathways, how the language in our Constitution governs those pathways regarding where a lawsuit ends up, whether it's the Vermont Supreme Court, the US Supreme Court, and how this language could affect it, because I do see it as more than just the symbolic change to our Constitution. So maybe Peter Teachout can get into that later on. And so Legislative Counsel Fitzpatrick responded, aside from any substantive differences there might be between what's in the language and what may already be protected by the Common Benefits Clause, the fact that it is in the Vermont Constitution makes this the final say as to how that language is interpreted would be by the Vermont Supreme Court, the federal court. I mean, the United States Supreme Court doesn't have any jurisdiction to interpret state constitutional law. So I think that including language that expands upon, provides more detail on protections of the Vermont Constitution, and therefore would be interpreted by the Vermont Supreme Court having the last word. By more enlightened with what we want to see in Vermont, as opposed to deferring to the federal courts of the United States Constitution, because those interpretations will depend on the makeup of the United States Supreme Court and the composition of the justices on that court. Put it in the Vermont Constitution, and you can rely on the fact that the last words of the state will be by the court in this state.
Doesn't affect you going. Eric, did you want to comment?
Sure, Eric Fitzpatrick, Office of Legislative Counsel. My response to that is that it doesn't prevent someone from going to the federal court to seek protection for their federal constitutional rights. It's just a common principle of state constitutional law, and has been for many decades, that the final say of the state constitutional provision is up to the state Supreme Court. So,
thank you. So you're interpreting that as, well, actually, let me re-ask the question. Can you tell me where I stated I intend to prohibit Vermonters from accessing the US Supreme Court?
So what I just read,
it seemed like I was asking Eric for further clarity about the issue of independent and adequate state grounds, rather than saying I intend to prohibit Vermonters from accessing the US Supreme Court. So they seem like they're completely different things. Is there anything else in the transcript that in which I do state I intend to prohibit Vermonters from accessing the US Supreme Court.
And I think in general, in the Senate, we have a rule in our permanent rules where we don't try to characterize other people's motivations because it's understandably and notoriously difficult. So I think Senator Hashim is the authority on what his intentions were with what he said. I don't know that it's profitable to go down that road, questioning his intentions there.
Senator Mahoney.
Yeah, I have a quick clarifying question for Eric, if I might, and the conversation around state versus federal Supreme Court. My understanding and sort of what we were talking about is that we can make our Constitution stronger and more protective than the US Constitution. And in an instance where ours is stronger and more protective, more people are actually protected because it's going through the Vermont system and not the US system. Yes, am I convoluting two different things? Because that's what I recall we were talking about in that whole back and forth was our ability to actually protect people more and not rely on the US Supreme Court. It's not a prevention of someone saying, well, I don't like the decision that was made here, now I'm gonna go to the US Supreme Court.
Yeah, I think I recall that being the basis of the discussion. That's also certainly has been true for a long time. Is that states are free to, that you could look at the federal constitution as a floor of protection. And states are free to enact their own state constitutional provisions which provide more protection. And now, still though, if the person were to go to federal court and look for a claim under the United States Constitution, that would be available. You're right that if someone were seeking a greater level of protection and the Vermont Constitution provided it, they might choose to go to state court instead.
So, I guess I'm just reading the Vermont Family Alliance website, and it says that you strive, will testify against Proposition 4 and other anti-parent bills. I'm not sure if you've explained fully how this is an anti-parent proposition. What is it about this this constitutional amendment that makes it anti-parent?
Whether the intent is expressed or not, there seems to be an intention here, given the testimony that was received during the walkthrough from different organizations. I don't think I got to teach us. There seems to be a move toward passing this proposition would give the legislature license to roll out programs and benefits. All of the testimony that you received was about the marginalized and state-sanctioned marginalized groups. Peter Teachout recommended adding a provision to keep it open-ended to add more groups that need to be protected. And historically, we've had the Constitution. People have not always applied it properly. They violated it along the way. They've treated certain groups of people with discrimination, and they haven't had equal treatment.
Parents are being discriminated against?
I'm trying to get to my point that this will roll out, if this is passed, if this proposition is passed, it gives the legislature license to create programs that offer benefits and programs to state-sanctioned marginalized groups at family and taxpayer expense. And it's at family expense. It affects every Vermonter, including Vermont families that are trying to earn a living and provide their own children or family members with the benefits of their hard work and the income that they earn, and to be able to freely expend those funds in the manner that they see fit, rather than through groups. I mean, I already covered the spirit of Article 1, that we earn everything through hard work. The testimony received during the walkthrough on January 30th indicated very much, sir, that that's the direction that this would go in. This maybe on its face, actually it is on its face, it would create a hierarchy of rights. It does when you leave religion out.
I'm sorry, I will demand that you show me in this language where it would create a hierarchy of rights when it says the government shall not deny equal treatment? How is that a hierarchy of rights? That's the opposite of a hierarchy of rights. Equality is the opposite of a hierarchy. So you said on its face it creates a hierarchy. Show me in the language how on its face you get to a hierarchy.
I think when you are listing,
Yeah.
listing specific groups of persons, that's not general enough. I would actually agree with Professor Teachout that it's not general. When you're listing specific groups, then you're not making room for every other, when you're listing specific groups, it needs to be general. You're listing specific groups. I would almost agree with Professor Teachout's recommended amendment for a standalone. And I don't know, I honestly don't know what other provisions you would need. We already have them under current law.
And that's a fine argument.
Yeah, we have strident, yeah.
I mean, that argument makes sense, and you can say that sensibly. But you keep saying things about this language that are clearly not true. And I'm just saying, what we are talking about is adding these words and no others to the Constitution. So when you say that on their face, they create a hierarchy of treatment, it is, I am stating into the record in no uncertain terms, it is the reverse. This language guarantees equal treatment for these groups because they have been the ones who have received historically unequal treatment. And so we are, to Senator Fiehowski's point, we are creating a stronger commitment to that equality than maybe exists at the federal level.
All right. I thank you very much for your testimony.
No, I wasn't finished. I didn't really get a chance to finish, but.
Oh, I'm sorry.
Yeah,
Oh,
if I may. I think
maybe I read ahead.
explicitly listing individual groups is the problem, and then it's not a general statement. And it should not be within Article 7. And wouldn't necessarily change my mind if, age isn't in here, religion isn't in here. I mean, how many groups are you going to list? It should be a general. It's supposed to be equal for all persons. I don't know that these individual groups need to be named, because what it does then is it sets a precedent within the structure of government. I don't know that I said, and maybe I misspoke or said it wrong, that the language itself creates a hierarchy of rights. I think I'm saying the outcome of it, if that makes sense. The outcome will be that. So I don't think I'm saying it's unconstitutional in its intent. So I don't think the language itself is necessarily unconstitutional. It's, except maybe, it's the intent.
How the legislature might.
Yeah.
Well, wouldn't that, if a future legislature uses something in the Constitution and does something that someone feels is unconstitutional, wouldn't that be up for a future Supreme Court to determine?
Probably.
I would think you would.
I think I was thinking about the man that stopped me in the grocery store a week ago. He's on Social Security, as am I. And he said, Vermont's one of 9 states that taxes your Social Security benefits. That's unfair. So I suppose one could argue that it's unfair to elders that their Social Security be taxed. But then if we did away with that, it would cost other people, other taxpayers, more to supplement the budget.
Mm-hmm.
I suppose that's one example. Another is, should the cake issue.
Yes.
So if you're a person who doesn't, for religious or whatever reason, doesn't want to bake a cake for somebody, but you're in business to provide cakes, should you be required to make a cake to sell a cake to a homosexual couple that's going to get married? That's one other example that kept coming up during the civil unions debate in here as well as the marriage. It was clear that at the time of the civil unions, we were talking about civil marriage, and so it was kind of unresolved. So I suppose that's one issue that one could get into here. But
Certainly,
I
sir.
happen to believe that they should make the cake, but I don't quite know why.
You think that they
Couple
should?
would choose them to bake their cake.
You think they should have to
Yeah.
make the cake?
Yeah.
You think they should have to make the
Yes,
cake?
I do.
Do you think a Christian should have, a Christian cake
I think
baker
if you're in a
should
public
be
business,
forced
I
to
don't
bake
think-
a?
I don't think you can decline customers if you're in a public business
Mhm.
for any reason other than behavior or, that they're stealing from you or whatever.
They can come in and buy cookies, cakes already made, make a cake for a birthday, make a cake for anything other. If a person, I'm a Christian baker.
I am too.
Yeah, I'm a Christian baker. I would bake
I didn't know
anybody,
you were
if
a
anybody
Christian
wanted to
baker.
come into my shop and buy a cake, you can do that. If anyone wants cookies, I would bake a birthday cake, whatever. But you're telling me right now, the intent behind this,
I didn't say that was the intent. I said it was an example of what we discussed
is that if
during
this
civil
is,
unions and
okay,
marriage. And I believe the US Supreme Court.
yeah. Back to the language,
Well, I'm done.
the language
I'm done.
on its face,
I'm done.
yeah,
I'm-
okay,
we need to
okay.
finish up, please.
Sure. So I will, yeah, let me see. I think what I just went through in the spirit of the law and the intent, I just went over historically, the intent of the law and what our framers intended through Article 1. And I think when we're looking at Proposition 2, we need to consider this spirit and intent behind
Do you mean
this
four?
proposition. So Proposition 4, it does create a hierarchy of rights, and you just expressed it, sir. So I don't even know if I need to go to further
I
than
don't
that.
think that I expressed the hierarchy. I expressed that if you're in business,
Well,
I
what
could
do you,
argue all-
yeah, I
you know
guess.
what, I could argue all day with you.
Sure.
We're both Christians, so get on with it.
Oh, sure, yes, sir. Let's see. Yeah, the concern is, okay, so religion is intentionally excluded. It was repeatedly claimed during the committee meeting on January 30th to be already covered under Article 3, Chapter 1 of the Vermont State Constitution. Yet the language in Article 7 would be amended in a way that would create a hierarchy of rights interpreted under strict scrutiny by Vermont state courts. Specifically, Proposition 4 would oppress the rights of persons and groups practicing Judaism, Christianity, according to the gospel of Jesus Christ, and Islam to live, speak, and act according to their beliefs without the threat of a legal suit against them if their beliefs, statements, and actions are perceived by a member of a state-sanctioned, marginalized, protected class to violate their rights, including the state-protected person's right to dignity, which is undefined in the purpose section of Proposition 4. I'm going to skip down to the bottom of page 5 and point to Jay Green in a state, just to get through this, because I know I want to be respectful of your time. Jay Green from the Racial Equity and Policy Research Analyst Office of Racial Equity at the bottom of page 5 here. He was quoted as saying, pardon me?
Jay uses they, them pronouns.
Jay is quoted as stating, I have concerns with some people using freedom of religion as an excuse to deny the human rights of people like myself, transgender people, and other people of the protected classes that are listed in Proposal 4. This is a clear statement that Jay Green thinks that his rights supersede other person's right to live out their faith. And as a foreshadowing,
Jay Green uses they, them pronouns.
I'm not going to put up with compelled speech. I will not do it. To live out their faith, and as a foreshadowing of the state laws and policies we can expect if Proposition 4 were to pass. That's another concern, Ms. Bahovsky. Senator Bahovsky. And we have to look at the intent. It could burden the taxpayers, including Vermont families, of cost administrating and providing benefits and programs afforded to only state-sanctioned protected groups. Professor Teachout recommended a standalone amendment. And at the last sentence of his, it is more general. His last sentence is the legislature shall have the power to enforce the provisions of this article with appropriate legislation. We don't know what that looks like. The last sentence provides power to the legislature to enact programs that benefit state-sanctioned protected classes at taxpayer expense. I don't even know if I need to, because I want to, let's see. Yeah, Reverend Mark Hughes didn't even notice religion was missing. And he claims that we need to, his statement on January 30th at 47:30, we need to double down to include the protection of every vulnerable category. And he said, Mr. Chair, respectfully, that's everybody that's not a white cis man. I would disagree with that statement that everybody's, that everyone isn't a protected class. Actually, I want to go back to Senator Lyons' statements on the bottom of page 6. She's a lead sponsor of Proposition 4, and she stated during her testimony before this committee that she did not know anyone who would not be a member of at least one of the listed groups: race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, or national origin. So she's saying, is Senator Lyons saying that everyone in Vermont qualifies as a member of at least one historically marginalized group and is therefore eligible to receive benefits and access to programs as a member of a protected group? And if yes, what does that expensive bureaucracy look like to collect taxes and then redistribute these tax revenues to every citizen in Vermont? So I think we need to look at the spirit of the intent of this amendment, and it's clear from testimony received, and even I haven't seen any data or evidence submitted of how people are currently continuing to be marginalized. Everyone is supposed to be receiving full treatment under the law, and we need to apply it appropriately. That's what needs to happen. Yeah, so I would say the spirit of intent behind this, that, Vermont Family Alliance strongly recommends that you vote no on this. And if you're not going to do that, that you consider taking testimony perhaps from another constitutional law firm. It's always good to get a second opinion, just like when you go to the doctor. You have a serious diagnosis, you get a second opinion. And so I would ask, you have Professor Teachout, I would ask that you seek a dissenting opinion and get their opinion. Have some clergy in here, Orthodox Judaism, Islam, I looked up Reverend Hughes's church website, the New Alpha Baptist Ministry. It's a social gospel. I would say that is very different than a church that teaches the gospel of Jesus Christ, and that you would take testimony from perhaps Catholic diocese or some other Christian denomination that teaches the gospel of Jesus Christ before you move to markup and voting. I think it's a little bit rushed today. I think I'm the only person representing an organization that has a dissenting point of view. So I would ask that you receive balanced testimony. And I apologize to you, sir, if I misunderstood Senator Hashim. If I owe you that sincere, and I need to go back and look at that. But that was my sincere understanding. I'm not trying to slander anyone or misrepresent anyone. That was sincerely my understanding of your intent. So I apologize.
Appreciate the clarification.
Yeah.
Thank you.
Thank you.
Yeah, thank you.
Is Mark Hughes still around?
Yes, I believe he is on the Zoom.
Afternoon, Mr. Chair.
Good afternoon, good morning.
Yeah, I'm out a little bit ahead of myself. I do apologize.
We've only got about 7 minutes, so if you want, I don't know how much time you need.
Yeah, I kind of figured as much.
Next week.
Yeah, I kind of figured as much, because I've been on for the duration of the previous testimony, and I figured it was gonna cost me. So how can I consolidate, instead of spending the next 3 minutes talking about how unfair this is, how about if I just figure out how to consolidate what I was trying to tell you? First of all,
Okay.
I'm Mark Hughes. I'm the executive director of the Vermont Racial Justice Alliance. I'm also the commander of the Veterans of Foreign War here in Burlington, and I'm a born again Christian, and I love Jesus Christ. He's my Lord and Savior, and I believe He died for my sins. Just for the record. I want to make sure that we're all talking about the same thing. What we're looking at here is there was a common agreement that we were going to defer to another article using the language of I think you asked Ledge Counsel to pull 2019's PR4, and we were going to look to implement Article 23 to the
We
Constitution.
have that, yeah.
And in that article, we discovered that religion was a part of it. So I'm trying to figure out what the kerfluffle was all about, but so just wanted to establish that. The other thing too is regarding intent. Again, bear with me, Chair, because what I'm doing is I'm trying to pull it all together here for you real quickly. Regarding intent, first of all, just to be really clear, Article 1 and Article 7 of the Vermont Constitution they are not collectively, they are not equal protection clause, and that's established law. That's what the rulings have told us. The other thing too is I do agree with the previous testimony. Didn't see that coming, did you? So I agree that we do have some time to put some more testimony on this, and I think we should just have a good old time with it, because I think it would also, first of all, I am aware that once this this constitutional amendment leaves this committee, it is unamendable, and it is we are proposing that it would be a part of the Constitution of the state of Vermont. If I've read the rules correctly, it is not possible to amend a constitutional amendment once it leaves the Senate. So I think that even if that weren't true, I think it would be worth, if there was additional testimony to be had of significant importance. I think the Attorney General would be a great person to come in and testify to this. Why? Because it's the Attorney General, obviously, that's going to defend anything that's legislatively constitutional, or determine whether or not, if and when this comes to a point where it requires defense, what that looks like. So yeah, I think that'd be a great idea. The other thing that I wanted to point out is this whole business of basic analysis, and we talked about. I'm the only lawyer. I don't know whether the previous witness is a lawyer or not. I'm certainly not even close to it. But I know there's this idea about basic analysis. It's not the 14th Amendment's equal protection clause that we're actually talking about, and how we're talking about how it's being implemented nationally in a nation that has a history of discriminatory practices. And yes, I'll say this, a racist nation. Please catch that for the record. And has created a bunch of inequities that what we're looking at, looking at addressing. I think that evidenced by the creation of the racial disparities in the criminal and juvenile justice system advisory panel. We talked about Jay Green and how they came and testified, and the office that they are from was a result of policy the following year. The racial equity director and the panel, all systems disparities report in 2018 showed us that there were disparities, ominously, that exist across all systems of state government. We know that the executive order that the governor introduced, as I said in previous testimony, the governor brought forward an executive order when it seemed imminent that the initial pass on this creation of this racial equity executive director's position was being vetoed. The governor did, in fact, also create an executive order to do so. Act 33, Land Access Opportunity Board, Act 1, and even your, as I said previously, your R113 2021, all state one premise that our previous testimony never broached, and that was this whole idea of this thing that we call systemic racism. So it appears as though that the legislature has determined that systemic racism is a thing, and that the executive branch has as well. Again, back to this whole basic analysis. What we know is with historically, with a United States Supreme Court with the supermajority conservative currently, and also we also understand that the courts themselves are conservative, that there has been an interpretation of the 14th Amendment that has been disfavorable on certain populations of folks because all of the impossibilities that have been created to actually leverage the 14th Amendment in such a way to where it would do what it was actually intended to do. And it almost seems senseless to lay this out in front of this committee because I think everybody sitting in the room knows what I'm saying. And I think the thing is that what we have to understand is that, again, back to the state constitution, what it becomes about is it becomes about what it is that we as a state, are asserting our priorities to be. And I'll just conclude this by saying that as we do this work, as we continue to do this work in the state, I heard a lot about spirit and intent, the spirit of the intent and so forth. It is my opinion that the intent here should be very, very clear, amongst the marginalized folks that we are seeking to address, as we have with all of the other aforementioned legislative actions that have been taken, as well as the governor's executive actions that have been taken. What we've established is that we are seeking to correct what has been damaged in the state, just as the current administration is on a national level. We're seeking to address that. It requires courage, it requires intention, and it requires precision. But here's the thing that it doesn't require, and that is it doesn't require denial. Because if we're in this committee and we're not talking about the fact that we're trying to address something that exists, then we're not going to really get to capturing the intent. And I think to the previous witness's point, it is super important that we do capture that intent. And it's okay for us to do so unashamedly, provided the Attorney General is prepared to defend what it is that we're seeking to do. What we can't do is we cannot vet what we're trying to do with the existing problematic structure. Because what we're trying to do actually to address systemic racism, for example, flies in the face of the existing structure. It's kind of the reason why we're amending the Constitution. It's kind of the reason why we're doing it. And the question is whether or not that is something that there is a political will or intestinal fortitude to defend. Are we as a state going to stand up and say, hey, we're going to do this, and we're going to do it in a way in which it's never been done before because it needs to be done. And what that means is that there's going to be a bunch of folks who feel uncomfortable with it. And I think I'm up for the challenge to hear more from them because this is a democracy. But at the end of the day, the compelling state interest, just to be crystal clear, the compelling state interest from my perspective, from my point of view, is we are here to eradicate systemic racism. That is a compelling state interest. And I think the same thing could be held true about other marginalized communities. And as far as the rule of law that's currently in place that refortifies and buttresses the hundreds of years of precedents that have happened at the national level that are currently being used to weaponize the 14th Amendment against marginalized communities. I think that it's that I'm here to reject, just to be very, very clear. I thank you for your time. I would just ask if you would, I should just make sure that this is very clear. This is, I am a little bit hurried because I'm trying to respect your time because I got 7 minutes.
Yeah, I've got to adjourn the meeting, Mark. We're already 5 minutes over our time. Can you come back next time we take this up?
I can, but if you can allow me just to get on record before I do leave.
Yep, go ahead. I'll stay. I've got other committee members that are leaving.
Okay.
They have other meetings.
I just want to be on record as saying is we want another article. We want another article. We want it to be intentional.
I agree.
I want it to be on record as saying is that the as far as what it is that we're trying to do, our intentions, we should state them clearly. And I'll leave it there. Thank you for the time. I would appreciate a few minutes because I can unpack some more of this stuff. And also appreciate the previous witness's position. It was just a matter of time before we had the opportunity to hear that position. I think it's important to hear.
Thank you. I do too.